Friedrich Ebert Stiftung Flight and Migration Competence Center, or FES-FMCC, was established to improve the migration dialogue between Africa and Europe and create a platform for fact-based discussions. FES has long believed in the power of engaging future generations to effect real change. Its various projects focused on creating inclusive policy dialogue and continues to renew its commitment towards encouraging active participation of the youth. The Flight and Migration Competence Center, or FMCC, is established with the very same purpose, with particular focus on up-and-coming migration policies and applying a human rights-based approach. The Civil Society Resource Center is a board-led society registered under Ethiopian law in July of 2019. The primary aim of the CSRC is to identify and support emerging and existing CSOs and thereby helping to rebuild civil society in Ethiopia. In line with its overall objective of empowering young civic actors and human rights defenders, the center proposed engaging the youth and addressing the issue of refugees in the country in the form of a moot court competition, and presented the same to its partners, the FES-FMCC. After joint discussions, the CSRC and the FES-FMCC jointly agreed to implement the 2022 National Refugee Law Moot Court competition. The next stage in the project was dispersing the hypothetical case for the first stage of the competition, in which teams submitted a memorial submission on the case. Out of 17 universities that made written memorial submissions, 8 were selected to move on to the oral round. The teams were Addis Ababa University, Arba Minch University, Arsi University, Dilla University, Haramaya University, Awasa University, Jimma University, and Aora Buntu University.
This competition, when CSRC collaboration with FES-FMCC was designed, it was designed with the objective of enhancing youth engagement in international refugee regime in hopes of mainstreaming these issues into everyday policy reform.
As FMCC, the Flight Migration Competence Center, it was the first time that we supported such a moot court. We discussed with our partner organization, the Civil Society Research Center, this project. We became pretty, I think, enthusiastic right from the beginning.
Expectations was empowering and mainstreaming refugee with the youth and future practitioners.
What I expect from this event is to be a launching ground for young lawyers, young policymakers, young change makers, for them to think about refugee law and how they can impact change on the lives of refugees, on how Ethiopia implements refugee law, and to sensitize these young lawyers about refugee law and its application and the gaps that may exist within the application of refugee law. I hope this event is also a networking opportunity for these young lawyers, networking opportunity among themselves, with teachers, with the different consultants and the different judges that they may meet due to this event.
During the open dinner ceremony, teams drew lots to determine the order of the competition for the quarterfinal. On the second day of the competition, Jonas Beramta, our refugee law consultant, conducted training on the refugee law frameworks. The training focused on understanding refugee rights as part of the larger human rights framework, key introductions on the historical development of refugee law, followed by a discussion on international, national, and regional legal frameworks.
This has been a very exciting experience that has made it possible to generate what you may consider to be a multiplier or a spin-off effect in terms of giving opportunity for these law students to further sharpen their lawyerly skills.
My name is Refugee Taddesa. I'm a fourth-year law student at Arba Minch University.
This is Maskara Mayale, and I'm from Hausa University.
My name is Johannes Shimelis, and I'm from Addis Ababa University School of Law.
My name is Bont Mulgeta. I am a fourth-year law student at Arsi University.
My name is Baraka Rashid. I came from Jimma University.
My name is Rafael Demelash. I am from Arba Minch University. I'm here as a coach.
And I expect a lot from this moot court competition. It's a well-organized moot court competition.
The training that is organized by this Moot Court competition is very helpful in understanding the subject matter of the refugee law.
This Moot Court competition, somehow it's a very nice, well-organized one, beginning from like the hypothetical case or the moot problem that the students have acquired, the relevant materials that they need to go through, even hypothetical case, legal materials have been provided on the moot problem. So beginning from like the written submissions, they were making some research on the relevant laws. So they already developed their way to legal research methods. And also in writing the memorial, they have acquired a lot, and the legal experience they got is also very high.
It will help me develop my skill of presentation in front of audiences.
I hope I will make better connections with friends here, since there are a lot of people from different universities that I wouldn't have met if it wasn't for this Moot Court competition. I really hope to get to know refugee law more, because it's not given as a course in our university. And
also great people who have come to accomplish, like me and my councils, to win this competition. And I hope it will be a great journey.
From the introduction, there are professors, doctors, and even the judges are working in the fields related with refugee law, and it's really relevant to help people. This Moot Court competition, hopefully, whether we win or not, I know it will change my course of life for the better.
This will give them the perfect opportunity to see if they want to be practicing lawyers, practicing litigators. So they will actually compete in a courtroom-like setting.
now that I've been here and have gotten the training from Dr. Jonas, it has helped me realize that refugee law and human rights are part of the same coin.
Impact has been quite tremendous, and that it has also given the opportunity for the students even to network among one another, so as to be able to get to know and be in a position to further nurture their knowledge of not only refugee rights but beyond, actually.
The oral rounds consisted of 3 stages: the quarterfinal, semifinal, and the final rounds. For the quarterfinal rounds, 8 teams competed against each other in the order that was decided by an open lot. In round 1, under bench 1, Jimma University as applicant versus Addis Ababa University as respondent. Under bench 2, Odabultum University as applicant versus Haramaya University as respondent. Under bench 3, Awasa University as applicant versus Dilla University as respondent. Under bench 4, Arsi University as applicant versus Arbamanj University as respondent. In round 2, under bench 1, Dilla University as applicant versus Arsi University as respondent. Under bench 2, Arbamanj University as applicant versus Awasa University as respondent. Under bench 3, Addis Ababa University as applicant versus Odabultum University as respondent. And under bench 4, Haramaya University as applicant and Jimma University as respondent. Each team competed in 2 rounds, once as the applicant and once as the respondent.
Discrimination as to race, religion, and country of origin. And second, Your Honors, the lack of as to distinguish, disclosing the reason why there is a need to discontinue group refugee recognition to these asylum seekers only.
Apart from looking into the constitutive elements and inclusion criteria of the notion of refugee, this has also given them the opportunity to familiarize themselves with international, regional, also national legal framework pertaining to refugee rights, and giving them the opportunity also to get to know more about the current paradigm shift in refugee protection across the globe.
Those conventions and the additional protocol, we have to use restrictive interpretation for that of the definitional part. As the definition of the convention and the additional protocol stated that the climate change refugees are not covered under the definitional part of the convention, as well as neither the convention nor the additional protocol of the 1967 acknowledge that the climate...
It's also important that they would play a constructive role in the future in terms of adding into legal research, in terms of advancing their career in the refugee law streams, filling the gaps in the shortage of refugee law experts in various areas, in the humanitarian sector, in the government, in the judiciary, and other places where refugee law rights are currently being implemented. As you know, also Ethiopia is currently rolling out what we call the Comprehensive Refugee Response Framework, and also the Global Compact on Refugees, which promotes a whole of society approach, including academics playing active role in the protection of refugees and also in terms of advancing their rights.
We give as a state complementary protection, which is in line with the United Nations High Commission for Refugees Executive Committee conclusion number Article 103. It provided that when the grounds for fear of persecution are not met under the 1951 Convention, a state should grant humanitarian assistance protection for those refugees. Our government has multiple obligations towards its citizens, and we have internally displaced people, and we have large number of internally displaced people. There is conflict in our...
Regarding the relevance of these kinds of competitions for refugee law to be promoted in law schools and in other parts, relevant areas, working closely with refugees, I believe that the number of refugee population in Ethiopia compared to refugee law experts in the country is unbalanced. Having the opportunity to train these law school students to have awareness, to have the knowledge in this area will be very helpful in having very competent experts in the future.
Comparative group for most favorable national and to treat refugees equally. Thanks. Okay,
Judges graded each team in the provided grading sheets, and the 4 top scoring teams advanced to the next round based on cumulative grades.
Moot 0-17 0-16 0-02 እና 0-08 ናቸው።
For the semi-final round, the top 4 teams selected from the previous day would compete in a knockout round. Each team would argue the side chosen by the draw only once, and grades were decided against the total grade of the competing team on each bench, and not by average across all benches like in the previous quarterfinal rounds.
Have refused their complaints regarding their accommodation to the Messianian nation, even though the government of Solaria granted favorable treatment for those foreigners who have treaties of bilateral, multilateral, and political agreements.
There were 2 benches for the semi-final round, and each bench consisted of 3 judges. Under bench 1, Addis Ababa University as applicant versus Arsi University as respondent. Under bench 2, Dilla University as applicant versus Armament University as respondent.
Now we will have some clarification questions for both sides. Honorable Ekrem, would you like to begin your questions?
Yes, I have a question for the applicants. I'm not entirely sure. In the course of your arguments, you have used a language referring to the applicants as migrants at some point. Can you, for the benefit of the court, explain how migrants are different from refugees or asylum seekers by invoking the relevant legal framework?
We have really excellent emerging legal scholars on refugee law that would be instrumental in promoting the rights of refugees in the future.
We can capitalize on the moot court competition as a multiplier effect. We can use these future lawyers on our effort to promote and protect refugee rights in Ethiopia.
Finally, I ask the Honorable Court respectively that reference group shall be foreign nationals of Solarian origin, not other groups. Thank you.
Assure the asylum seekers that they will not be deported and that they will be provided with complementary protections. Time to file an appeal on their matter. So So because of these reasons, the decision of ORA does not constitute.
Even all three of the judges in my bench were thinking that it will be a pity for only one of the teams to advance to the next stage, because it was a very close competition, their argumentation and litigation skills, and they were prepared well for the case. So it was a very close competition, and I expect that it will be even more competitive in the final round, because their argumentation skills, their preparedness, their responsiveness to the questions was really admirable.
The teams that made it to the final round are 008 and 00170. Representatives from Team 008 and 0017. Once Addis Ababa University and Ardamanut University were announced as the winner, as per the rule of procedure, it was decided that Ardamanut University would argue as the applicant, and Addis Ababa University would argue as the respondents for the final round.
Expect that it's going to be a tough competition.
I don't know who's gonna win, but I'm pretty sure that it would be a tough competition. I'm just excited to see what will happen.
For the final rounds, teams had 27 minutes to present their arguments and counter-arguments. Unlike the other rounds, once teams made initial submissions, the court recessed for 15 minutes, followed by an in-depth question and answer session where both teams were questioned on key normative refugee frameworks.
I think both parties are present, as we can see from the situation. You're going to have 27 minutes for presentation of your case, both the applicant and the defendants. You can allocate your time amongst yourself. Yeah, you can also reserve 7 minutes for your rebuttal, if you like. And we start with the applicant. Please introduce yourself and go to your case. One minor change from the past 2 days. We're going to have interjections in the middle of the presentation, so questions may be raised. So prepare yourself for questions and answer in the middle of the issues. Your time is going to be maintained accordingly, and you can reserve that. And the time is for the applicant now to present their case.
Good morning, Your Excellencies. Today we appear as an applicant representing the lawyers for refugee rights, and we have attached our certificate of representation with our submission. Today, the applicant will submit 9 pleadings, and the first 3 pleadings will be addressed by me, and I will be using 7 minutes. The following pleadings will be addressed by my co-counsel, Mr. Basukad, and he will be using 8 minutes, and the last pleadings, including the prayer for relief, will be addressed by Mr. Basukad, and he will be using 7 minutes, and we have reserved 5 minutes for rebuttal. Thank you. Rejecting the application of asylum of refugee from Russia constitutes an error of law. The first reason is that the refusal of the state of Solaria to grant a refugee status for Russian asylum seekers, contending that they are climate migrants and does not fulfill the requirement of the definition of refugee, is inconsistent with its international obligation. Russian asylum seekers flee to Solaria because of unprecedented flooding, and this flooding put much of Russia underwater and destroyed many crops. So they don't have any other option rather than fleeing to Solaria. So this falls strictly under the spirit of Article 1, Sub 2 of the 1969 OAU Convention, and as well as Article 5, Sub 1, C of the 2019 Refugee Proclamation of Solaria. As the asylum seekers flee to Solaria because of a serious event, and this serious event which brings or results a serious disturbance in public order. And Your Honor, in addition to this, the government of Russia was not in a quite adequate position to provide any support and protection for the Russians. So because of this first reason, the decision of ORA rejecting the application of asylum of refugee from Russia constitutes an error of law.
The hypothetical case that they have been discussing pertain primarily to refugee rights, like I said, and a variety of issues have been looked into from the outset. This has also made it possible for them to look into issues regarding the definition of who a refugee is.
FGM is a form of persecution, and it is affirmed by the development of the regional and as well as international human rights instruments. And also, it consists of torture, inhuman treatment, and cruelty, which is affirmed by the evolving jurisprudence, the legal doctrines, and as well as human rights councils and European Court of Justice. So, expelling or returning these girls to a place where they will be subject to this form of persecution, particularly FGM, is in breach of Solare's international obligation.
Specifically on the grounds that you mentioned. So specifically to the case of FGM, what ground are you presenting now that this group of persons must be protected? You have said about particular social group, you have said about religion, you have said about political opinions. So in this specific case, which is the ground that you want us to use in terms of interpreting the convention?
So far the competition is going really smoothly. What I have learned is these future lawyers, future judges, future prosecutors have a very good understanding of refugee rights in the international and the national refugee law framework.
That cause serious disruption of public order. Now, when we look at the article, we can see that there are two vague or generic terms, and they are event and public order. And as law of interpretation suggests, if a term is vague, we need to interpret it, and we need to we need to be cognizant of the four main points I'm about to mention when doing the interpretation. The first one is the intention of the drafter. As we all know, the OAU was drafted in order to deal with the specific issues of refugee problems happening in Africa, and at the time the drafters wanted to protect refugees coming from other countries due to colonization. So we need to keep this in mind when we interpret this article. Additionally, we also need to be cognizant of the term or the interpretative tool, just generis rule that states that if a general term comes after a specific term, that generic term should be interpreted in line or in part with that specific term. And in this case, when we look at the instances mentioned under that article, they all denote to a man-made disaster, man-made external disaster. And this shows us that natural disasters, like environmental disasters, were not meant to be included under the OAU Convention.
I think the court has said your cases, your rebuttals. We've already taken note of your memorials already. Now the court is going to be in session for the next 15 minutes and come back and raise question of the court.
Court stand. Court recessed for 15 minutes, followed by an in-depth question and answer session where both teams were questioned on key normative refugee frameworks, after which the judges adjourned the court to make grade submissions.
So what we did as a judge was to evaluate students' performance on a number of parameters, including to what extent students, observe court rules in terms of, for instance, court language, the extent to which students were able to persuade the judges in the manner of their presentation, the extent to which they use, proper legal analysis, and so on and so forth. These are factors based on which students' performance are evaluated, and then we hope that we use these parameters very carefully so that the best law school is able to win this competition.
Chosen Murat to represent them, so Murat will be giving the awards and he'll be getting the speech when it comes to the winner round. So the best memorial goes to Alabama University. Next up is best oralist. Best oralist goes to Moot.
Overall experience in this 5 days has been really amazing because I got the chance to meet new people. I got the chance to experience the things I never would have thought I would experience. The fact that I participated in this specific moot court competition helped me to know more about what, because I did not even know about, I knew about the mojo, but I didn't know it was this specific, this detailed. The fact that it can touch so many laws, so many land laws, property laws.
Second runner-up is RC University. First runner-up is Moot University. And the winner of the National Refugee Law Moot Court competition is Addis Ababa University.
This is my first moot court experience. It was a very eye-opening experience for me. I have never imagined myself speaking in front of a huge number of people and being asked questions and being able to answer, and it really showed me that if I could put more effort into my public speaking skills, I could do more. So I am glad that I was part of this competition, and I wish this competition could go on. I wish more opportunities could be given for every student from different parts of Ethiopia, because I believe that if everyone is given a chance, a resource and also a training, they could do more and better, and that was my overall experience.
Expectations was empowering and mainstreaming refugee with the youth and future practitioners. The program has reached that goal and surpassed our expectations in how the students have interacted and how refugee was discussed.
The Flight Migration Competence Center, it was the first time that we supported such a moot court. We became pretty enthusiastic right from the beginning, to do it with law students, because when you look at refugees, they are usually one of the most vulnerable groups of people, and so they lack access to legal remedy. They quite often even lack the knowledge of their own rights.
In a way, this has been quite a tremendous opportunity for law students across different universities in Ethiopia.
The CSRC is extremely excited about piloting this project. As our first ever moot court experience, we think it was a success. The plan is to regionally expand next year, hopefully, so bring in schools from all over Africa, especially within the East African region.
The idea was, as I said, as the Flight Migration Competence Center, we're not just focused on Ethiopia or the Horn of Africa, but we're working on the whole continent.
We never had a time to socialize when I was law student there, but these 5 days were eye-opening for me. I get to know him and he got to know me, my other teammate Jordanos Nega and also Yohannes Shimelis. So it created a kind of bonding moment for us.
Honored to be part of this particular initiative. I'm very thrilled to see that we have now emerging scholars who are interested and who are very enthusiastic about promoting the rights of refugees. So
I hope they prepare other moot courts, because it has been really amazing.